Hi, my name is Dave and I'm an attorney in Illinois. I want to talk to you today about how real estate is handled in a divorce. As you probably know, real estate is usually the biggest asset people have. So it's very important how real estate is handled within a divorce. Let's get going. Okay, so let's get into real estate in a divorce. I'm just going to refer to real estate as a house because that's often what people have. This could apply, however, to a condo or some other type of real estate that you own. Now, real estate is very important in the context of a divorce. Obviously, there are a lot of financial implications. Okay, so real estate is often the largest asset people own. It can also be a very big debt if real estate is underwater. That is, if parties owe more on the real estate than it is worth. So no one wants to get stuck with debt, right? So there are financial implications. But also real estate is sometimes difficult to deal with because people are living in real estate. For example, you might live in the house that's involved in your divorce. Your spouse might live there. Your children might live there. One or all of these people might want to keep living there. One of the people might want to have the place sold very quickly. So there can be a lot of complications and a lot of conflicting interests, let's say. Now, for the most part, a house can be either agreed upon, so you can agree upon what happens to a house, or the judge can decide. Now, this is true regardless of whether or not your divorce is an uncontested divorce in Illinois or a contested or litigated divorce in Illinois. And here's why. Now, an uncontested divorce in Illinois means that both parties agree on all issues in the divorce. One of those issues being what to do with the house, what to do with real estate. So if you're getting an uncontested divorce in Illinois, you and your spouse or partner can agree what to do with the house. For example, you could agree that it be sold, you could agree that it goes to one party or the other party, you can agree that you both own it. We're going to discuss more about all those options later. The point is, in an uncontested divorce in Illinois, both parties can agree as to what happens with the house. Now that might be obvious because an uncontested divorce in Illinois involves agreement. But what about a contested divorce in Illinois? One where people fight in court. Well, you can still come to an agreement on some of the issues. That means there's less to fight about in court. You might be able to agree about what happens to the house. Okay, so in other words, let's say in a contested divorce in Illinois, there are various issues like what to do with the real estate, what to do with retirement accounts, what to do with the kids, what to do with child support. There might be issues about spousal maintenance. There could be any number of issues. If you can knock off any one of those issues, it makes your case more simple. You don't want a big case, you want a small case. So if you can agree what to do with a house, that benefits you a lot. Okay, so the information that I'm going to give you in this video applies to uncontested divorces in Illinois, but it also applies to contested cases. Okay, so before we get into what people can agree upon in regards to a house, I want to just give you some insight into what often happens to a house if there is litigation and a judge decides. Now, it's true that a judge can award a house that is the property of the marriage to just one of the parties. But often that doesn't happen because to get to that point, there usually need to be a trial. Most cases that are litigated don't actually end in a trial. They end in some sort of agreement. Furthermore, to get to the point where a judge will award a house to one of the parties, you have to have a fairly complicated trial about that. You'd have to involve real estate appraisers. You'd have to involve some sort of market analysis of the house. the judge would have to decide how much is the house actually worth, and does one of the parties have enough money from their share of the marital estate to essentially buy out the other party's interest in that house so that they can keep the house. Okay, so that gets to be a very complicated case. It could happen that a judge awards the house to just one of the parties. In other words, you might get it, or your spouse or partner might get it. However, often, and I would say very often, the judge will order that a house be sold. Because then guess what? The judge doesn't have to worry about what does some expert like an appraiser think that a house is worth. The judge just has to worry about ordering that the house be sold. And the house will be worth whatever the market thinks it's worth. So that is often the most simple way to do things. And judges like simplicity. And frankly, simplicity can often be better for the parties, because rather than spending a lot of time litigating and not only paying for houses to be appraised, which is fairly affordable, but actually paying for an appraiser to come to court to act as an expert witness can be expensive. First of all, you have to pay the appraiser. You have to pay the appraiser not only for the report, but to show up in court. You have to pay your lawyer to prepare the appraiser to give testimony. You have to cross-examine, or your lawyer does, have to cross-examine the other party's appraiser, and that can take a while in court too. So it takes a long time to fight about things in court, including fighting about real estate and what it's worth. Therefore, the most simple solution is to, bring down the cost of litigation and just order that the house be sold. That's what a judge can do. And that's often what happens. And the judge will tell people, I'm going to order this house be sold, so why don't you two just agree the house be sold right now and let's get this done. So keep in mind, if you fight in court about what should happen with a house, often the judge will just order that a house be sold. Okay, so now we're going to talk about what are some of the options that people can agree upon if they can agree on what to do with the house. All right, so we did already discuss that both parties can agree to sell the house. Now, even then, there are some more details. I can't include all of the details in this video, but I want to give you an overview. So if both parties agree to sell the house, they need to decide, is the house going to be sold right now? Are we going to put it on the market now? Or will it be sold later? For example, when one of the children graduates high school or maybe even college, or if it's, for example, December. Sometimes people don't like to sell or buy real estate in the winter. So they might say, well, we're going to sell the house, but we're not going to put it on the market now in December. We're going to put it on the market, let's say in March or April or May or something like that. Okay, so that's an overview of what people need to agree on when they agree to sell real estate. Now, of course, there's other details like I mentioned. For example, what broker are they going to use? How are they going to split the bills? How are they going to split the funds received from selling the house? What lawyer are they going to use for a real estate closing? But the main thing is, when is the house going to be sold, if it is going to be sold? Okay, so now I'm going to talk about what happens when one party, or I should say both parties, agree that the house or real estate will go from being owned by both of them to being owned by only one of them. And for that type of situation, we would call it a buyout. That's because the party who will keep the house, we'll just call that the receiver, will need to buy out the other party from that other party's interest in the house. So I want to run a simple scenario by you. And of course, this only applies, that is, a buyout only applies if there is equity in the house. If people owe more on a house than the house is worth, there's no buyout because it's only debt. So this only applies to scenarios where people can make money if they were to sell their house. That is, their house is worth more than their mortgage balance is, okay? So a buyout applies to that sort of situation. So for example, let's say that a house has a market value of approximately $100,000 and the mortgage on the house has a balance of about $100,000. That means there's about $100,000 in equity. Some people might call that profit that would be had if the house were sold. So that's a $100,000 asset really. But keep in mind, that $100,000 asset is essentially owned by both parties in the marriage, assuming that house was bought or acquired during the marriage for the most part. So if that house is owned by the marriage, that's $100,000 divided between the two people in the marriage or civil union, because what I'm saying now does also apply to a civil union in Illinois. So I hope you enjoyed that overview of dealing with real estate or your house in an Illinois divorce. Now throughout this video, I've given you examples and information. I don't know what you should do in the context of your own divorce. If you want advice about how to handle real estate in your divorce, how to write up a sufficient clause in your marital settlement agreement to agree upon what should happen with the divorce and the house, then you need to retain an Illinois divorce lawyer for that. So make sure you do that, because making mistakes in regards to real estate can be very expensive. I don't think it's something that people should try to do on their own. Consult a real estate lawyer and an Illinois divorce lawyer if you have questions about dealing with real estate in your Illinois divorce. Thanks a lot, and I look forward to seeing you next time.